So it appears that the Rhode v. Bonta California ammo ban case is now back in the hands of Judge Benitez. So let's talk about this. But real quick before we jump into this video, if you agree that California's ammunition restrictions are unconstitutional, go ahead and hit that like button and subscribe. How's it going, everyone? My name is Anthony Miranda. I am a licensed and practicing attorney in the state of California with an emphasis on Second Amendment rights. I've been part of Second Amendment litigation both at a state level and a national level while serving as a staff attorney with the Firearms Policy Coalition legal team. My goal with these videos is not to provide you any legal advice, but instead to give you greater insight into the Second Amendment litigation that's currently going on at a state level and a national level. As I mentioned in the intro, in this video we'll be discussing the state of California and their ban on ammunition, and the case which is challenging that, which is the Rhode v. Bonta California ammo ban case. It appears that the Rhode v. Bonta California ammo ban case is now once again heading back into the hands of Judge Benitez, who prior ruled that this restriction in the state of California is indeed unconstitutional. Now, if you're not aware, Rhode v. Bonta deals with the state of California's restriction on the purchase of ammunition and also the background check system that you must go through to actually purchase ammunition in the state of California. This provision was passed through Proposition 63, which requires purchasers of ammunition in California to undergo one of the two background checks, which will essentially confirm that you are legally able to purchase ammunition in the state of California. There is the basic eligibility check, and then there is the basic eligibility check, and then there is also the standard eligibility check, both of which come with a fee that you are charged to purchase ammunition and to go through that background check system. This law in California also restricts the ability for someone to be able to purchase ammunition online and then have that shipped directly to them at their home. Instead, in California, all ammunition purchases, even online purchases, must go through an FFL where a background check is run and where the transfer is then performed. So that is essentially the law in question in the state of California, and that is what's being challenged in the Rhode v. Bonta case. Judge Roger T. Benitez, or St. Benitez as he's known in California, is the district court judge who originally reviewed this case. On review of this case, Judge Benitez implemented what can be best described as a version of text as informed by relevant history and tradition. He described this test as a simple Heller test. He stated, Heller asked whether the law bans the types of firearms commonly used for lawful purposes. He reiterated it's simply a hardware test. Using the simple Heller test, he stated, it's obvious that California's background check laws that de facto completely block some law-abiding responsible citizens from buying common ammunition is in fact unconstitutional. He pointed out that under the Heller test, the review could end at the first step and he wouldn't need to go any further in his analysis. However, he also went even further in his order to find that an ammunition background check has no historical pedigree at all. In fact, he stated, a background check required every time you purchase ammunition has never been implemented before, and the first time that this has ever popped up is in the state of California. Now, after his ruling, the state of California appealed that decision up to the Ninth Circuit. Procedurally, Rhode v. Bonta has already been heard, and oral arguments have been held, and those were held in November of 2020. But the ruling by the three-judge panel in the Ninth Circuit has been essentially on hold, and it was on hold because there was a bunch of other cases at the Ninth Circuit level, and also because the Supreme Court was reviewing the Bruen decision. Now, after the Bruen decision, the panel in Rhode requested that the parties issue supplemental briefs to the three-judge panel in the Ninth Circuit, essentially arguing how and in what way that decision by the Supreme Court in fact impacts this ammunition case. The state of California submitted their briefs, and they first argued that Bruen has no impact on this case because states' ammunition restrictions do not implicate conduct protected by the text of the Second Amendment. But they also argue if the panel does find that the right to purchase ammunition is protected by the text of the Second Amendment, then the Ninth Circuit should remand the case back down to Judge Benitez for reconsideration of the case in light of Bruen. In opposition, the plaintiffs in this case filed briefs arguing why the Ninth Circuit should keep the case and rule on the case in light of the Supreme Court's decision in Bruen. The plaintiffs argued that Bruen has clearly eliminated the two-step approach that the Ninth Circuit has used in the past to justify these types of restrictions. That type of analysis is clearly incorrect now because under Bruen, Justice Thomas expressly rejected that two-step approach, and he said that it was one step too many, and he also expressly rejected the use of intermediate scrutiny. So that fact is really important because the whole basis on which the ammunition restriction was built on was intermediate scrutiny and the public's interest. The ammunition restrictions were passed because it was argued that the public's interest outweighs the right to purchase ammunition, and therefore there needs to be eligibility checks or background checks on every single purchase of ammunition. Second, the plaintiffs argue that history and tradition prove that Judge Benitez was correct in enjoining the California ammunition law, and that this is the first of its kind ever to exist in history, and therefore there is no history and tradition to actually support what the state of California is doing. They go on to state that California's ammunition regime, by the state's own admission, is the first ever of its kind. Indeed, throughout the legislative and ballot initiative in passing this ammunition law, the legislator had said that this was a historic measure that would make California the first state in America to impose background checks on the acquisition of ammunition. And then they point out, while the state of California argues and promises that they have strong arguments that support this regime, that there are strong national historical traditions of these types of regulations, they say that they will not present them to the Ninth Circuit because they are saving them for when this case is remanded. Then the plaintiffs went on to argue to the Ninth Circuit that California is simply trying to get a fifth try at this case in an attempt to try to scratch out some sort of historical support, which is now required under Bruin. But again, they're not going to be able to find any historical support, so their next best strategy is to try to get this case dragged out for as long as possible. So that's really what California wanted, and now it appears that's exactly what they're going to get. Strangely, today we received a docket entry from Judge Benitez in his court, and it's a status conference entry that's been set for December 12th, and that is for the December 12th Rhode v. Bonta case. However, there's one confusing part to this story, and that's the fact that the Ninth Circuit 3-judge panel has not yet remanded this case back down to Judge Benitez. We have not received an order from the 3-judge panel on this issue yet, but there's still a status conference that's being set by Judge Benitez and his court, which likely means that Judge Benitez knows something that we don't, and that the remand order is likely coming soon. Now, we all kind of knew that this was coming because the Ninth Circuit has already remanded all of the other California 2A cases, and even other 2A cases like the Young v. Hawaii case. All of those have been remanded back down to the district court, so it was likely only a matter of time before the Rhode case was remanded as well. However, once we get that remand order, if we get that remand order, I would suspect that there's still going to be a dissent in that order, likely from Judge Bumate, who has been very pro-2A, who's been very vocal about the Ninth Circuit's outright refusal to uphold the Second Amendment. So he's likely going to say that he does not agree with the panel, but ultimately you can get outvoted as long as there's 2 other judges on that 3-judge panel who want to remand the case. All you can really do is just say, I think you guys are doing the wrong thing. So a lot of you were asking me, where does the California ammunition ban case currently stand? And that should give you a good idea of what's currently going on in this case. December 12th, Judge Benitez has now set a status conference for this case, Rhode v. Bonta, and this case is likely going to be remanded back down to him, and that's why he's doing that. And now he will get to reconsider this case, Rhode v. Bonta, once again in light of Bruin, and I suspect that nothing really is going to change. He already ruled before using text, history, and tradition, even before the Supreme Court issued their decision in Bruin, so I don't really see anything change. I don't think he's all of a sudden going to have a change of mind and change his strategy and his analysis. If anything, I think his analysis is going to be even more resolute that he got it right the first time. Another interesting thing is that right now, December 12th, there is going to be 3 of the California 2A cases before Judge Benitez at various stages. He's hearing various motions and various status conferences. That's the Miller v. Bonta case, which deals with California's ban on so-called assault weapons. The Duncan v. Bonta case, which deals with California's ban on so-called large capacity magazines, and now the Rhode v. Bonta case as well, which deals with California's ammunition restrictions. So it's going to be really interesting to see what happens December 12th, because 3 of these major 2A cases that have been going, that we've been waiting on, are now going to be before Judge Benitez on December 12th, and now he has control of all these cases once again. So if we get any more information, if anything else changes, I will let you all know. If you have any questions, go ahead and comment down below, and I'll try to answer the best of my ability. Also, if this video and support the channel, and the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of 2A news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.